Rocket Launchpad. And now, here's Johnny. Johnny Rocket here at the Johnny Rocket Launchpad, launching ideas in your direction. A Northwest only rock and roll libertarian radio show. I'm here with my co-host, Mr. Kurt Nelson.
Yes, sir.
The voice of reason, the beautiful Heather Nixon.
Hello.
And we are here with Professor Tom W. Bell. Bam! Woo! Yeah! Explosion! Bam! Hey, thank you very much, Professor. This is really great. I really love your explanations on this stuff because I think it's very difficult for a lot of people to wrap their head around copyright. And it is kind of confusing.
Oh, very confusing. Well, I am a professional. I mean, what I do is explain stuff all day long.
Yeah, well, you're good at bringing it down to earth for us guys.
Yeah. I guess the point of this show is to kind of let people learn about liberty on a, blue collar level. And that's what we're trying to do. We're not trying to get all ivory tower on everyone's ass. So how do you get a copyright and how much does that cost, generally speaking?
Well, to actually get it is really pretty super simple because if you're in the United States, you simply fix the work in a tangible medium, write it down, record it, whatever, and boom, your copyright rises right there.
Mm-hmm.
But to register it, that's a different thing. You got to fill out a little bit of paperwork at the Copyright Office, the U.S. Copyright Office, and it's pretty cheap, actually. If you do it online, they have this electronic system. It's just $35 for a single author. Say you write a song, you're not a corporation, just a guy.
Mm-hmm.
$35, that's pretty simple, and you can do it all online with a credit card. Took a couple pages.
What's the difference between a copyright and a trademark?
Big difference, actually. Basically, copyright protects something that has content. It's something you want to listen to or read or look at, painting, whatever. A trademark is more like an indicator. It's like a name that helps you find things you want. So copyright would be Microsoft Windows protected. Nike's swoop is a trademark.
Okay.
So you don't give Nike money because you want really, the swoop. You want the shoes, and the swoop just helps you find them. Whereas when you give Microsoft money, you really want that software. You want the copyrighted thing.
You want the expression.
Right.
Yes, the expression,
Right on. Very cool. And I think that's interesting. It's like, so if you have a business and you have a logo for your business, you should get that registered trademark on the logo for your business.
Well, actually, you don't need to register it. It should remind you a little bit of copyright in that a trademark can arise without you filling out any paperwork. It's simply using some sort of indicator of identity, usually a name, but it could be a symbol, it could even be a song, lots of ways to create a trademark. You use it in commerce. You use it in commerce so that people recognize it, consumers recognize it as, you're Sam's best shoes ever, and so they can find you. Yeah, and once you do that, you have standing to sue. If your name is Sam and you do business under Sam's Best Shoes Ever, and some guy opens up shop next to you with the same name and you got there first, you can shut him down, even though you don't register. You can register, but you don't have to.
How does that work with when it starts going like interstate? If there's a Sam's Cool Shoes in the state next door, is there a federal thing?
Yes, there is. That's one reason you might register. When you register with the federal government, you get automatic national protection.
Ah, okay.
If you didn't register, let's say you're in Ohio and you're using Best Buckeyes for the name of you make desserts, okay?
Mm-hmm.
And somebody's using a similar mark, a confusing mark. That's the test, whether or not someone else's mark is confusing consumers. But they're over in Illinois, and you've never sold a single one of your pastries in Illinois. Ohio courts are probably not going to help you, nor will Illinois courts, because they'll say, it's another market. There's no consumer confusion. Whereas if you go to the federal level, boom, you can shut them down as soon as you have your registered mark. You don't have to worry about that cross-border activity.
Okay, good to know.
One other thing with copyright, let's say you have a CD, right? So instead of going through and hitting every song, paying $35 first song, $35.
No, I think you can do the whole record.
Can you do the whole record where it's like a collected works?
Yeah, you can do that.
Okay, I wasn't sure how that worked.
Yeah, you have options. You can do the whole song. You can do the whole album, as you said, a collective work, or you can pull out the individual songs.
And they both offer the same protection.
Well, I'm not sure I'd say that. There might be good reasons to actually register the songs separately for, reasons that are kind of technical. All I'll say is you're getting to the point now where I'd say talk to a copyright attorney.
Okay.
But for you say you want the blue collar version, I'd say if you're an artist, you're worried about infringement, then at least register the CD.
Yeah.
Right.
Well, here's a for instance. Let's say you have a CD, you go on, you register the whole CD, but now you want to sell songs individually on iTunes.
Right.
And now is there some sort of thing that, because you've got the individual songs broken out?
Right.
I'm sorry. So you're asking whether you can sell the individual song on iTunes if you've only registered the CD?
Well, if it's still protected, if the individual works are still protected, if you're marketing them in a single format
versus a collection,
even though you registered the whole album as a collection of works.
Interesting.
Yeah. Well, again, you're getting a little technical now, but if I understand your question, it would probably work like this. Yes, you would have copyright protection of the individual song, but you wouldn't get the full benefit of all the remedies. It's kind of like these scenarios we worked through earlier where Jewel gets ripped off by Taylor Swift. It's that kind of problem again.
Sure.
Okay.
Not because you didn't register, but because you registered, the wrong sort of thing.
Interesting.
Wow.
Sure.
So
it can be very complicated. Yeah.
Regarding the length of copyright and how good it's, lifetime plus 120 years or 170 or 70 years plus life of the creator. Do you think that's too long?
Oh, yes, I do.
Okay.
It's way too long. It's been extended time and again. The thing that I like to do is continually return to what the founders thought about copyright.
Okay.
And we actually have pretty good evidence of that in that right after they ratified the Constitution in 1789, they passed the next year. And it was pretty much all the same people, right? Because there were only so many politicians in the United States back then.
Mm-hmm.
They passed the 1790 Copyright Act.
Okay.
And the maximum term, the most you could get under that Copyright Act was 28 years. 28 years, not life of the author plus 28 years.
Just 28 years.
Oh, interesting.
28 years. So you think about it now. You create something when you're, say, 35, you live to be 70, life of the author plus 70, you're looking at 105 years. That's like around 5 times as much. And I don't think that's necessary. People seem to create pretty good stuff under shorter copyright terms. What's I think happened, I'm pretty certain what has happened, is that basically the content lobby, Hollywood, some Silicon Valley publishers, they basically keep going to Congress saying, gimme more, give me more. Right. Congress gives it to them.
Wow.
Yeah.
Like, let's just say we're the offender. What if someone gets sued for copyright infringement? What could you do?
Well,
like, look at
what
it
can
from
you do? Oh, like
I'm the asshole who stole something from somebody, and I'm like, I got busted. I got caught. Any advice from you?
Don't do that.
Stop stealing things.
Oh, my bad.
If you do it, don't admit it like you just did.
Well, I didn't. I'm just being hypothetical.
Yeah, I know. Well, basically, your hypothetical is actually a pretty simple one in that you say, I take it the scenario sort of, I took the whole song and I just copied it. Like I'm burning CDs in my basement.
Right.
Yeah.
Right.
Well, that's really, it's against copyright, and you'd get busted, and they would be able to shut you. Assuming they've registered the work, they'd be able to get injunctive relief, we call it. That's basically a court order shutting you down. Right. They would be able to get, the copyright holder would be able to get damages or profits, maybe statutory damages. It may even be, if you really are running a CD press in your basement, there could be criminal sanctions for pirating.
$150,000.
Yeah, no, you've heard of these deals. Back in the day, I don't know if it's still happening, but I remember back in the day, there was a guy in the neighborhood that I lived in where like the FBI trucks rolled in and confiscated. This guy had a basement full of
that's crazy though.
He was taking laser discs. Remember the giant
the
laser
records
movie? And he was copying movies onto VHS tapes and reselling them. And the FBI arrested him and confiscated everything he had, and it was a big deal.
So that
they can seize the stuff that he uses to make it too. They can take the CD presses, take the laser discs, and they put them under bulldozers or burn them or something.
Yeah. It was, and I'm assuming that guy probably. I mean, this guy walked out of his house in handcuffs. It was criminal. It was a big deal.
There have been people, so here's how crazy copyright has gotten. There have been people who have been dragged off to at least, temporary jails until they got out, but, they were arrested for using their cameras in movie theaters. I heard this story about a woman in, I think it was a Chicago suburb. She got this new phone for her birthday. A new camera for her birthday. And, digital cameras these days, they have video features. And so she's going to this birthday party. They went to see Twilight, her and a bunch of her friends. Mm-hmm. And she's got this new camera, and she's going, oh, hey, Nancy, smile and all this stuff. And she's running her camera, and she does a little bit of video. She captures like maybe 1 second of the Twilight film.
Oh, Lord.
Oh,
and
come
they
on now.
find her and they drag her off the police station, and because she violated this federal law against recording movies in theaters.
That's crazy.
She got off the hook, but still.
Still, yeah, it's like a pretty serious
Well,
deal
she has
for
a lot of,
one
she has a lot
second of a
to-
movie.
She's going to go to work, be like, I got arrested last night. I was at Twilight.
I'm looking at your map of intellectual property right now on my iPad. And down at the bottom, I see it has the little copyright symbol, 2003, Tom W. Bell. So if I were to say, hey, Tom W. Bell was on the launch pad and here is his map of intellectual property, does me acknowledging that it's your work and your little symbol on the bottom, is that good enough, or do I still need to get your permission to share that?
I'd say it depends on a couple of things. One is my intentions, and as you guys know, with my stuff, I put it out there, and it's pretty much, hey, if you want to teach somebody about IP with this, beautiful. That's what it's all about. If you were selling it in a case book, that's if you're making money on it, then I might get cranky. That's one thing. And then the other question is sort of it's related, what do you do with it? Sort of what do I allow and what do you do? So if you, for example, put it in a book where you say, here are some teaching styles that different people use, and here's an example of a guy who uses graphics. It's kind of like a picture. And I'm just in there as an example. You could probably claim fair use. You could say, I myself am an educator. This is for an educational purpose. It's a very small use of his work. It's integral to this larger work that I'm creating. So I don't need permission. It's fair use. It's a defense a lot of people get to use.
As long as she's citing it and giving you credit and all that.
Well, actually, that would not really, strictly speaking, make much of a difference. The thing about copyright is it's a strict liability offense. If you violate a copyright, even if you do it innocently, you say, oh, I thought that song was in the public domain. I thought it was an old folk tune. Nope, copyright protected. Oh, I'm off the hook because I didn't mean to do anything.
Nope.
It's like the ignorance of the law thing.
Ignorance of the law is no excuse. That's correct, yes. The only thing it might affect in Heather's scenario is, if she really tries to show respect and then she gets caught and she gets sued and she loses, the court might take into account, if it's asked to assess statutory damages. It's just the judge kind of sitting on the bench, and the judge says, you're not a bad person, Heather. I can tell you made a mistake, so we're not going to hammer you as hard as we might. It might help there, but that's all.
So anytime you're going to share anything like that, you should get permission, shoot an email and say, yes, you're allowed to share my material. And that would be good enough to cover you.
Well, that would be good. I really honestly can't say that's always necessary. I mean, and the reason I say that is because you got to consider how easy it is to infringe copyright. I'll give an example. So one of you guys maybe sends me an email, and I forward it to my family saying, hey guys, I got to cut out at dinner early so I can do this. You can see I have this email invitation. Well, strictly speaking, I made a reproduction of your copyrighted work, your email. Did I have permission? Well, we'd say impliedly you have permission, right?
Right.
But you didn't write on your email. You can share this with your family members for, coordinating your calendar.
Right.
So that's why I'd say I would not say always ask permission, because at some point it's just crazy. It's just obviously not infringement.
Right, because it's implied if you give someone a poem, then, you kind of gave it to them.
Yeah. And so ditto, if I have something online, you've seen my website, I put all my stuff on the website, I want to share it with the world. If you're just sharing it in a classroom, or you say to your friend, oh, this Bell guy has something he might help you with, it might help you understand your problem, here's the link. Right. You're helping them make a copy because they, basically when they load it on their browser, they're making a copy in the RAM of their computer. I'm okay with that. How could I not be okay with that if I put it online?
Right on. And like the same thing what we do on the show, we play local rock and roll music. And so what I do is before these shows are put out, I get on the phone with these guys, these musicians here, and I'm like, hey man, we really want you to be on our show. We want to, feature your band as the band of the week. Would you be cool? And they're like, oh, absolutely, Johnny. Here's our record, here's our CDs, here's our music, here's our bio. I'm like, right on. Thank you very much. And they're like, oh, can't wait to hear it. I got their permission from evidence mail, right?
Yeah. Well, that's the other thing to say about what Heather was asking. I mean, if you ever have any doubt, she said, well, just ask him. I wouldn't say you always have to, but I do have to agree. Both of you have said this, and I agree totally. If you get permission, and it can be oral, it doesn't have to be written down. It's nice to get it in writing in case they renege, but strictly speaking, just they say, okay. That's called a license. It's a non-exclusive right. And basically, it's like someone saying, you can step onto my property to deliver a package. It's, it doesn't mean you own the property. You get to use it for a second.
Good point.
Daryl Fortune tells another another story about ASCAP where they actually came into his office and he's playing music that he's got permission from every artist, but they don't know this. So they come into his office and, with guns blazing and he's like, well, how about if I get the guy on the line? And they're like, well, we need to see written proof. He's like, nope, hang on. And he dials the guy up and he's like, hey, ASCAP's here saying that I don't have the right to play your song. And the guy's like, that's freaking crazy. You can totally play the song. And and they were like, oh, okay.
And they walked out.
And they walked out. I mean,
that's great. They called BS on him and they walked.
Yeah, totally.
Well, hey, speaking of now we talked about copyrights, which is awesome. And you kind of cleared up a lot of things. And I think our listeners are grateful for it because this stuff is confusing. I think we broke it down pretty easy. Let's get into patents.
Oh
boy.
Oh boy. Here we go.
We can be a little more brief on this subject here, but just give us a general. What is a patent and how long are they good for and stuff like that.
So let's start with how long they're good for. That's simple. It's date of application plus 20 years.
Okay.
Date of application plus 20 years, and a patent covers new, useful, and non-obvious inventions or processes.
Mm-hmm.
An example would be, well, golly, they're all over the place. I'm looking at my laptop right now. Apple is big in patents. So I'm sure there's probably 100 patents in what I'm looking at right now.
I bet there are.
And it's just like technology. It could be also the software. You can get a patent on software. A lot of people don't like those. You can even get a patent on business methods, which I think is a little sad, but it's true. So yeah, it's useful stuff that people invent.
Wow. In your videos, you were talking about Walt Disney and how he built a multi-million-dollar company on something that we all have access to.
Mm-hmm.
Can you talk to us about that?
Sure. Disney, many of his early films and even a lot of the later ones are based on stories that are in the public domain, myths, fables, legends, that kind of thing. So Cinderella, Snow White, Pinocchio, all that stuff. I guess in some of those cases, we don't even know who originally wrote the story. It's just something that's bouncing around the dark forest in Germany, the Black Forest. All right, so Disney says, I found this great story. It really tugs on people's heartstrings. I want to make a movie out of it, and Disney does, and then claims a copyright in the result. Is that legit? Well, yes and no. To the extent Disney adds its own authorship, its interpretation of the story, everything they add, that they can claim as their copyrighted work. What they can't do is say, you don't get to write a story about Cinderella. You can't make a movie about Snow White.
Sure.
Interesting.
But the thing here's what happens with Disney. This is why people get toasted. They say, okay, so I'm going to make a movie about Snow White too. I like Snow White. It's public domain. And Disney says, fine, but don't copy our stuff. All right, I am. And then they go out and they make this movie about Snow White. But, Disney's version is kind of like seeped into the culture so deeply. A lot of times people are copying Disney and they don't realize it, or they're not copying Disney, but Disney can plausibly say, well, their Snow White looks a lot like ours. Don't you think, Your Honor? And you can't pretend, says Disney, you can't pretend that they didn't see our Snow White. Everyone has seen our Snow White. And so then they get, the premise for a copyright infringement claim.
And plus they have a crazy amount of lawyers too.
Do not mess with Disney.
Yeah,
Right.
totally.
Scary.
Well, and we're talking about public domain. So you're saying hey, there's all these old books and Cinderella and Rumpelstiltskin and all these things that Disney has taken from old public domain and all these old titles that everyone's forgot, reinvented them. That's old stuff. Now, is there any new stuff that is public domain?
Yes, actually, but it's not because the copyright is lapsed. It's for other reasons, and I'll give you some examples. Section 105 of the Copyright Act says works of the United States government are not copyright restricted. So that's kind of awesome. You don't have to worry that you're violating copyright if you cut and paste some federal law or regulation, into a document.
Mm-hmm.
And that means court opinions also. So other stuff that gets in the public domain, it could be because, and I've done this myself, people just put it in the public domain. In fact, a lot of my stuff, Heather noted I have a copyright mark on that IP map, but a lot of my stuff, I just don't copyright it at all. I say, in fact, it's not copyrighted. Please, feel free to use it. And that does happen. People do that not just because they're nice or dumb, but because they're greedy and smart sometimes. Because here you can actually get, for example, CD-ROMs that are just full of images you might want to use, say, in your PowerPoint presentations.
Mm-hmm.
A picture of a cartoon of a guy with a briefcase, a picture of a lady wearing a nurse uniform, whatever.
Right.
And you don't want to fool with tracking down permission on this. So you buy one of these CD-ROMs and bam, you get 1,000 pictures of guys with briefcases. You get exactly the one you want.
Right.
And so that stuff is in the public domain. That's the way, you're comfortable using it, but you had to pay for the CD-ROM, and that's how they make the money.
Sure.
Right on.
Sure.
Professor, really quick, what industries don't have copyright laws? I thought this was really interesting.
Oh, it's super interesting. There's these whole areas of creativity where basically there's not just copyright, but basically no intellectual property restricting access. And that includes jokes, recipes, furniture design, perfumes, clothing design.
Interesting.
Yeah, all these areas. I could go on. There's some more. Auto body design.
So a car design can be copied.
Yeah, we're talking about the shape of the car,
right.
Sort of the fenders and everything, not the technology inside. And I could, get into why, but just, if you can trust me on that, let's make the observation that everyone says, oh, we got to have IP because otherwise no one will create new stuff. Do we lack jokes or new perfumes or recipes or no, we don't. Or new fashion designs. Fashion design is really interesting because, that's a really active field. New stuff out all the time, a lot of money involved. Basically, they can't stop people under the law from doing knockoffs of new dresses and suits and things.
Wow.
And yet it works. People create new stuff all the time. In fact, some people have argued, I think pretty convincingly, that the reason fashion design is so active and creative is because they have to keep running. They don't have IP to protect them. They got to come out with new stuff in order to make the next sale.
Very interesting. Professor, one last question before we wrap this up, and we want to bring it home here with the intellectual privilege. Talk to us about your idea of intellectual privilege, and let's sell this.
So I call my book Intellectual Privilege because I think, although there's some truth to calling copyrights a form of property, it's apt to mislead very often. And I say this especially for my friends who share libertarian views. I'm afraid they've been bamboozled. Sometimes, some of them anyhow, because they hear the word property and they think a libertarian or conservative or classical liberal, they hear property and they think, well, I like property. So I better like this copyright thing. But then when you look into the details, you discover, wow, it's really very different and just in a lot of ways from what really is property. And that is to say, the old common law types of property, real estate, movable property like computers and dresses and cars and things. And so basically, I think the advocates for copyright have pulled one over on a lot of people. They've kind of appropriated this label property, which kind of fits, but it doesn't fit really well.
Okay.
And it makes it easier for them to get people to swallow what they're pushing, down their throats.
And so are you trying to say that we should make intellectual property more of a common law thing?
No, I wouldn't say that. I would say I'm suspicious of statutory protections generally. I trust the common law more. It's based in this bottom-up process. It's kind of organic and flexible.
Sure.
It's traditional. It's, down to earth. Whereas you know what happens in Washington, D.C.,
right.
And what you don't know would make you feel even worse.
Right, yeah,
Totally.
So, basically they churn out page after page of all these rules, regulations, laws, and stuff because of lobbyists. They're not looking out for the public interest so much. They're just seeing what they can get away with. And that's where copyright comes from. And so I don't trust it. So I prefer if we can do things through common law, let's do that. I do encourage people. I'm trying to get policy to move away from doing everything through these top-down orders.
Okay, I agree.
So that's one thing. And I'd also say I want people to think about copyright a little more skeptically. I'm not anti-copyright. I'm not saying let's get rid of it, but I will say we should always be asking ourselves, do we need that much copyright to get the creativity we want? You look at fashion design, I think you kind of go, well, I think we're doing fine without any kind of IP.
Sure. Interesting.
And I think we should expand that kind of critique and ask, gee, do we really need life of the author plus 70 years to convince somebody to write a book or somebody to write a poem or to create a new movie? We probably don't. We're probably restricting really freedom of speech. It's really a restriction on freedom of speech. We're restricting freedom of speech more than we have to, and that's a bad thing.
Anyways, host Johnny Rocket here at the Johnny Rocket Launchpad, launching ideas in your direction. The Northwest's only rock and roll libertarian radio show. I'm here with my co-host, Mr. Kurt Nelson.
Yes, sir.
Voice of reason, beautiful Heather Nixon.
Yeah.
And we're here with Professor Tom W. Bell. We're going to have some more questions. We're going to do Rocket Fire. We're going to listen to A Woman's Place, and we'll be right back. Bam!